welcome to the Relationship Clinic podcast. I'm Renee Natvig, your host, and today we continue our series, Divorcing with Dignity. My special guest today is Carina Leeson. Carina is a family law and collaborative divorce attorney at the O'Mara Law Group. After many years of handling high conflict litigation matters in South and Central Florida, Carina promotes the use of alternative dispute resolution methods, which includes the collaborative law process. She feels that while litigation is sometimes necessary, it should be a last resort and not the first course of action, especially when children are involved. She's committed to helping her clients stay out of the courtroom and focus on their future. Carina is an active member of the Collaborative Family Law Group of Central Florida. She was recently elected to the Board of Directors at the statewide level of the Florida Academy of Collaborative Professionals. She is committed to the growth and the development of collaborative community and the families it will benefit. Enjoy the interview. Welcome, Carina.
Thank you, Renee.
To get started, maybe you could help people with just an understanding of your perspective on the range of divorce options available to people and where you find yourself in that range of services you offer people and what you think is important about each of them.
Sure.
A lot of questions, maybe.
Sure. Well, I want to start off by saying I'm a native Floridian. I've been here my whole life, primarily here in the Central Florida area, but I've been practicing family law for over 15 years. The family law issues that I deal with are ones that most people are familiar with: divorce, paternity, alimony, child support, time sharing, modifications of those issues. And certainly there are a lot of options for people who are in need of those legal services. Most people are most familiar with litigation, which is, you go to court and you kind of duke it out, and you've got the husband and wife or mother and a father fighting over the issues that are relative to their divorce or family law issues. But there are quite a few other options. There's also mediation, which is an opportunity for people to meet with a neutral third party who will facilitate resolution for them without having to go to court. Kitchen table negotiations, and they sit at their own kitchen tables and they
I imagine they have a kitchen sink full of things that they try to resolve, right?
They do typically, but those are folks that can kind of work through the issues. They know what's important and they do it themselves. There's there's another way to do it, and that's the collaborative law process. The collaborative law process, I'm really passionate about that process for several reasons. There's so many advantages to it. Most important is that it respects and protects people's privacy. Mm-hmm. It is confidential, and it keeps a lot of people's personal information, their personal finances, their personal issues in private. And that's really important to a lot of people, is having that anonymity, especially when dealing with such sensitive and private information and details about each other.
How is it that maybe you can let people know why it is that it can be so private versus litigated?
Well, when you're in the court system, you're subject to all the court rules and the court procedures. Family law rules in litigation are they're very set in stone. They're statutory. And so there's certain requirements that you need to comply with, and there's certain disclosures that you must comply with, and that's all statutory by Florida law. Mm-hmm. So those are requirements that must be done once you decide you're going to litigate your case, and your case is going to be in the court system. Mm-hmm. Whereby the collaborative process, or even some of the other forms, but primarily the collaborative process, it's a voluntary process, so both parties have to agree to it. And by that agreement, there's a whole set of other rules that apply, one of which is you are not subject to the requirements that would otherwise be imposed on you if you're in the court system. Mm-hmm. So that's one of the huge benefits to people, certainly whether you have high net worth or not. Mm-hmm. Some people prefer to keep their finances and their issues private, and the collaborative law process is an important way that you're able to do that. Some of the other advantages of the collaborative process are that it helps preserve your assets. People think that, they always want to ask, and they want the comparison, what costs more? Is it going to be litigation? Is it going to be the collaborative? And there's a lot of controversy about what costs more. The truth of the matter is that you really don't know what the cost of your case is going to be if you decide to litigate it, because it's basically, the wild, wild west sometimes. Your lawyers will sometimes do things. You will sometimes want things to be done. You can't control the other side and the other
right,
lawyer.
Responding to what the other side.
And so you've got all of those issues that go through what essentially is your marital estate. Whereby in the collaborative process, there's a lot more control over those expenditures, and there's a lot more transparency over those expenditures.
How is there more control? How does that happen in collaborative?
In the collaborative process, the parties agree and the professionals agree, because there's a team of professionals, if I can explain that a little bit. Each of the parties has their own representation, so nothing's changed in that regard. Typically, each party has their own lawyer in litigation. So that is the same in the collaborative process. But there's also two other individuals, a neutral mental health professional and also a neutral financial planner, a financial expert. And everybody agrees they will be transparent about their fees, they will be transparent about their costs, and that's actually talked about in the process, so everybody knows where they are. You know what your expenditures are going to be pretty much month to month. So when you're scheduling your meetings, you find out what the transparency is for each of the costs of each of the professionals, and that is just something that helps everybody know where they stand as far as what's being spent in what period of time. In litigation, it's nothing like that. There may be months where there's little activity, and then there will be a flurry of activity, and so there's just a spike in your fees. And you never really have control over what they are. In the collaborative process, you have expectations, you have goals, and the team is there to support those expectations and to support those goals. And they're done in a series of structured meetings, and so that's what I mean by control. Those meetings are set for a set period of time, over a period of a month, or they can be sooner or later, depending on what the team and the parties primarily want. But that governs the pace at which the divorce process goes forward.
And both people are understanding, it's as far as full disclosure, they're not spending on each side and not sure where that money is going for the other person. I don't know how much that matters as far as how the agreement, how it finally gets settled, is a big pot being taken out of both, and they have no idea who's spending what, versus in collaborative, it's on the table.
Right.
They're making I almost think of it as kind of like a budget. Like once you're aware of it and it's out there, you're laying it out there, that seems like it would offer more awareness and consciousness,
and therefore the control part of it,
right?
And so that's certainly helpful for folks when they're in the middle of a divorce and somebody has to pay for it, and it has to be paid out of some source of funds, and that's 100% correct. The transparency is at the very beginning of the process. How are we going to fund this? It's a joint expenditure, for lack of a better word, and now how are we going to fund it? And so when people take that into their own hands, that gives them the control to determine what source of funds, and it may change from meeting to meeting. So instead of having to go to the court and say, hey, I need some of this money over here, or I need some of that money over there, or the other party has to pay for my funds, my fees, this allows the parties to have that control themselves and say, this is where we're going to take it from.
Okay.
This is our source of funds to help us get through this process.
And they come to that agreement.
Right.
Okay.
Right.
Yeah, right.
So, and that transparency does afford people that sense of control, I think. As do the structured meetings. The structured meetings also help people feel like they're in control of the process. And the basic premise of the collaborative process, let's not forget, is to give control to the parties whose lives are being affected the most, and that would be the two people going through the divorce.
Right.
So it's not just the financial aspect of it, it's the decision-making process of it. That being the most important, I think, is giving my client and the other collaborative professional, giving their client that control to make those decisions that affect their lives, not just through the process, but after. And contrast that with going to court and having a judge who's a stranger making those decisions. People can feel pretty powerless in the courtroom. So this gives them and empowers them to make those tough decisions and have those tough conversations. It's not an easier process. And sometimes it's a harder process, I would argue, because you are taking responsibility and you are being held accountable for making those decisions. But that's what's so powerful about it. It allows people who are going through this process to make those tough decisions about their lives, about their children's lives, and focus on the future and stay out of dwelling too much on the past. But you have to somewhat. But this is really more of a forward-thinking process. Whereas when you go into court, you're oftentimes talking about all the things that have happened in the past to support your position, right? And this is a much more forward-thinking process, and it really helps people get from that stuck place or staying stuck, and it helps them transition and move forward and focus on the things they need to going forward.
What a good model of how things are going to be too, right? That one possibility is that people get stuck in thinking about the past or blame or whatever, and this model almost supports a new kind of being together, looking
the new existence,
right.
And especially with people who have children, and the younger it's even more impactful. But at any age, when you have children and you're expecting people to get through this process and then successfully co-parent, I've seen a difference. It's night and day.
You've seen the aftermath
I've heard, because I think through the collaborative process, it's a different dynamic and a different relationship too between the lawyer and their client. So there's still that, that contact afterwards oftentimes. And what I've heard is that they've just been in such a better position to co-parent their children because they've reestablished new boundaries. They've either developed or learned new communication skills with one another by way of the collaborative process, which really helps and supports their new post-divorce family. So that's really, something powerful as well, because I for someone who cares about families and the children of the families, this is a great way to help build a foundation for them to be successful going in the future after this transition of their divorce is done. So that's really something transformative that I really enjoy and am happy to facilitate for many people.
That's something that you're right, is totally separate from money. It's a lifestyle of connection that people are figuring out how to do differently, but no less valuable.
Right. And I think, again, when you compare it to litigation, the whole concept of going to court is for, each of the parties to be pitted against one another. That's basically what happens when you go to court. And again, it's focusing on all the things that he or she did badly during the marriage or immediately before the filing of the action. And so you're kind of opening those wounds further and exposing them when you go to court. And I think that forces the people who are there in the courtroom to relive those things. I think it's
so part of dignity. Then we're talking about divorcing with dignity. Is you're not reopening those wounds and sharing them with everyone that are on both sides.
You're absolutely correct. You're absolutely correct. And it's not to say that in the collaborative process those things are not addressed.
Okay.
They're just addressed differently. They're addressed in a dignified way. They're addressed where people can express themselves. They can be heard, and people feel like they have a voice to say those things if they need to. But certainly that by itself allows people to move on and to move forward.
How is that expressing themselves, do you think, or your experience, different in litigation? Because people are expressing themselves, right? They're either digging up or making everyone aware. How is that expression different in that collaborative process? When people are sitting in the room, how are they expressing what they want to say, would you differently?
Well, I mean, I know that when I work with my collaborative clients, we always have meetings before we have the team meetings. And as part of the collaborative process, we call those structured series of meetings that we have team meetings. So I will often, if not always, meet with my client before those team meetings, one-on-one, to find out what are their concerns, what are their goals. I will give them some guidelines on this is how we should maybe bring this issue up, and how do you feel about talking about this. So I think part of that pre-team meeting dialogue that I have with my clients helps them feel comfortable with being able to then talk about it at the team meeting. And then let's not forget that once we're in the team meeting, we're in a room surrounded by professionals that are committed to this process. So it's not just me that wants my collaborative client to be heard, it's the whole team that wants the collaborative participants to be heard. And so I think that process, as it's unfolding and evolving, it's encouraged so that there is that comfort level. I can reflect on a collaborative case that I had in the first team meeting. My client really was scared to say anything. She was writing down notes, and she would talk to me after that meeting, and by our third or fourth meeting, I saw a different person. Because she now felt the support of the team and the process, and she felt comfortable enough to start voicing her concerns. And she didn't have that dynamic. She had the same dynamic in her marriage of not talking, and through the collaborative process, I could see that she was now being able to express, her voice, and she was voicing her concerns and her issues and her feelings, and so that was neat to see that transformation. But I think that when you're in the courtroom, you're sitting in the witness stand. You're
under attack, or at the very least,
either by a series of questions by your lawyer or cross-examination from the other lawyer. It's not,
and high stakes, right, for every statement you make.
Very high stakes. And when you're in that setting, you also have to keep in mind too that the judge is looking at your demeanor and your presentation, and sometimes under that kind of stress of being in the courtroom and in litigation, it doesn't come across as well as it might otherwise. Sometimes the message gets lost.
Or your intention.
Right. And when you are in the collaborative process, things slow down considerably. So those things are all allowed to come in at the right time and at the right pace. So I think giving that time and that space to those things really helps dignify the process, and it lets people be heard, and that in and of itself is really a way to facilitate productive conversation and settlement in an amicable way.
I'm smiling because I'm thinking I both work with couples who are trying to connect more, maybe move in the direction of staying in the relationship, and also this process where people are moving out of it. But in both ways, that slowing down process that allows people to feel safer and think more clearly. It's important both ways, no matter what your goal is.
And circling back to what we were talking about a little while ago about control, and the parties keeping control of the process. The collaborative process is instrumental in that, only because you're exactly right. Maybe somebody needs to take a step back. They're feeling anxious about a particular topic that we might be getting ready to talk about. Maybe it's alimony, maybe it's child support, maybe it's the time sharing schedule. And we have a meeting that's scheduled. So how do we handle that? One way that we could handle that is by saying, okay, we need my collaborative participant needs to take a step back. We need to maybe push this meeting out a week or two, and try to have that addressed either individually or with the team to try and handle that. And I think that, again, contrasting it to a court date,
right, that you don't mess with.
You don't necessarily have the luxury of that, only because either the judges set that hearing and we can't get out of it, or the next available hearing time is not going to be for 3, 4, 5 months down the road, and that's going to be too long out. Litigation, some people don't realize that in a regular divorce case where you have, W-2 wage earners, you have a house, you have cars, you have kids, and if it's contested, you may be in litigation for a year or more just to get done. Whether you actually end up going to trial or not, because most people don't. Most people end up settling their cases outside of trial. They may still have to go down that litigation track, but most people end up settling their cases.
With the litigation, but not necessarily going to trial, going to court.
Right, they do. But the difference with the collaborative process is not only does that happen a lot sooner, we're setting up the participants to get it done much more efficiently. And, again, much more peacefully than they would be doing it. And they're not subject to court deadlines. They're not subject to court availability. These are all things that they put together with their team and is scheduled accordingly. And so if someone does need that extra time, then there's the ability to do it without delaying the process unreasonably. So that's always a big plus in my book, because most collaborative cases can be accomplished and be done from start to finish, I would say generally speaking, within 4 to 6 meetings, which may translate to 4 to 6 months. And when you contrast that to, a year or more in litigation and the additional costs and fees of litigation and the emotional stress of litigation, that's really refreshing to know that it can be done that quickly and that peacefully.
Awesome. As you were sharing about confidentiality and transparency, so is it your experience that people are pretty forthcoming about everything between the couple? Do they grow in their kind of ability to share more and not be so scared about it? Is that sometimes a struggle? Is that sometimes go rather easily?
I think it's definitely more of a struggle. For one, generally speaking, one person has been handling the finances.
Right.
So unless you're coming in with parties that have equally been handling the finances, there's always the person who's been handling the finances, and there's the person who has not. And the person who is not is coming into it, I think, with a little bit of distrust. That is the responsibility of the team to help lift that person up.
Okay.
And that is also why we've got the benefit of the joint financial neutral. Okay, that person is really there, not on anybody's side. They're really there to say, listen, here are the finances. This is how you've been doing it. This person has been handling this. This person has been handling that. And so when you have that neutral person, that starts to build up the trust of maybe the less trusting participant. But it is a responsibility, I think, of not only the other spouse, but more importantly the team, to help support that person, help them have the level of trust that they need to go forward. But that also is part of how the collaborative process evolves.
Okay.
But it is important because and I think circling back to the confidentiality of it all, that helps give that transparency to the finances.
It encourages them.
It encourages. It definitely encourages, because they know it's not going to be thrown, in a court pleading or a hearing. So that helps them get all that information where it needs to go.
So when they
make decisions.
So when they go to the judge, then at the end, some people might not realize that all of that information stays within those parties when they go to the judge to have that final divorce short hearing or whatever. The judge and the court documents don't show any of that financial information.
There's still some limited financial information that is required depending on what county that you're in. But for the most part, a substantial amount of that financial information is kept confidential, as are the discussions that you have. Very similar in mediation, where the information that's shared during mediation is kept confidential. All of those negotiations, all of the option building, and the parties' personal finances, much of that is kept confidential.
That's definitely an advantage that way then.
It is.
Okay. So if you had the opportunity to, share with people that were just starting their journey, and I'm sure you often do this, I'm not sure in what kind of way, but they're just starting their journey to thinking about what they want to, how they want to move forward. They know that their relationship is not going to survive in the same way, that they're going to part paths. I'm kind of stumbling over my words because I'm thinking, but there's still probably going to be a family if there's children, so it's not that they're parting complete ways. But in this new form, how they're going to move forward, and what do you say to people?
I'll start with what I say during any of my consults. I first explore why they're there, because sometimes people are really just getting information. They may not have made the decision, or they're still contemplating whether they are going to try to save their marriage. And I always ask that question to every one of my consultations. Where are you in this process? Have you made a decision? And if they tell me no, I encourage them to go see a counselor to see if that's if reconciliation or something is if their marriage is able to be salvaged. So I do that. That's at my first consultation. For those folks who are a little bit further along and they're saying, no, I think we're headed in that direction to get a divorce, then I will go through the different options for them to go through that process. They can do it themselves without lawyers. They can meet with a mediator who's the neutral facilitator, with or without lawyers. They can do the litigation route, which most people are most familiar with, or they can explore the collaborative process. So I explain what the collaborative process is because most people have not heard of the collaborative process unless either they know friends who have utilized that process or they know professionals who they've talked to about that process. So I explain that to them, and I oftentimes send them to our local collaborative chapter's website or statewide chapter's website so they can get some information, they can process it, they can see if that's something that might fit them. But 9 times out of 10, any consultation that's sitting with me would be a candidate for the collaborative process. And I would argue that litigation should be the last resort and not the first resort. There are many other ways to try to resolve their issues and resolve a case that don't involve litigation. And I personally think that should be the last resort because it's just, sometimes it's necessary. Sometimes it just is necessary because one person is just not going to cooperate and they're not going to, they're just not going to move forward the way that they need to. So they do need that court intervention. But the majority of cases, I would suggest, should look at other options before considering litigation. And I would suggest collaborative is something everybody should give serious thought to.
Has that been your experience that sometimes people start out that they are thinking they want to litigate and somehow they turn around in their thinking? Or I guess I'm wondering about, as people who might not be appropriate for collaborative, can people be educated in a way that makes them feel better about it? Or what's your experience about some people? What's that sense of people that that it's probably just not going to be helpful for them to consider?
Well, like I said, I think it's helpful for most cases for them to consider it. I think that they need to be paired with professionals who are educated and trained in the collaborative process, because I think they're going to be the ones that really help promote the process to their client, especially where clients, maybe they were not in control of the finances during the marriage. So I'm going to circle back to that particular topic. But let's say they were not the person that handled the finances. They may not feel confident, for lack of a better word, to say, oh yeah, the collaborative process is the process for me. So they're going to look to their professional, they're going to look to their lawyer. Should I do this? Should I not do this? And as the lawyer, if the lawyer is not trained and doesn't have a good understanding of the collaborative process,
it's going to be hard to recommend.
The message may fall short. And to those individuals, I would say, if I was, because I have clients that come in and they said, I want to do collaborative, but my spouse won't. And it has to be a voluntary agreement by both parties before you can do the collaborative process. Otherwise, you can't do it. That's just the way that works. So they come in, they say, I want to do it, but my spouse won't agree. So, I can sometimes reach out to the other lawyer and say, have you explained the collaborative process? And I'm hopeful that they have, since that is one of the options that we do need to represent to our clients, that is available as a way to resolve their disputes. And if that doesn't work, I sometimes will go back to my client and circle back to them and say, see if you can get your spouse to talk to the neutral mental health facilitator, just to meet with them and talk to them about the process to see if they can alleviate your concerns. So there's different ways that we can try to help in that situation where one spouse wants the collaborative and the other just won't agree to it, because most of those people are not agreeing to it based out of fear, because they either don't know about the process, they don't trust their other spouse, they're scared because of the divorce, and perhaps they just haven't been educated enough by their attorney to have a sense of comfort about that process and having it resolve their issues.
Right. And I like your suggestion that it doesn't always have to be an attorney either, that there's mental health neutrals that people can talk to who definitely wouldn't be biased as far as...
And that's the beauty of the process. That is the beauty of the process, is you have this network of other professionals who are affiliated and are committed to this process, and we are here to help those that are transitioning in this process. And so that is available as a resource to us. And maybe you have someone who will respond better to the neutral financial expert. Maybe we have somebody who's a numbers person.
Right.
And why don't we put you in touch with the financial neutral who can talk to you about, how the numbers of this, how the numbers of this work, and maybe they need those metrics to help them have a comfort level with the collaborative process. But certainly there is that network of professionals that can help guide the parties and hopefully get them to a place where they feel comfortable about the process.
That's such a... it also demonstrates the actual collaborative system or process, that you might resonate with one person more than another, and you've got all of these support people, so building your trust with, if someone's more of a numbers person or if someone is speaking more from an emotional place, you've probably got two spouses, one more comfortable in one area than another, but you've got this network of people that are supporting you.
Right. Right. It's definitely kind of that it's, as far as images, I'm thinking of a net, and the whole team is in the net, and we're all kind of, holding each other in place, and that, it's maybe sometimes going to be imbalanced here and there, but we're all going to stay within the net. Whereas in litigation, it's going to be more of like, it's like a tennis match or, volleyball, and you hit the ball over here, you hit the ball over there, and, it's not so much of a point system. This is more of a collective group effort, and hopefully, you just move the process along, and it gets to the finish line, which it typically does. And again, we're trying to help facilitate this process in a peaceful and dignified way.
And if someone does get stuck, I think this was another important point as we consider the different options. Sometimes people make a lot of progress, right, in that collaborative process, and maybe there are some sticking points where it's just not getting done, and that people don't have to totally abandon the collaborative process because they couldn't get, whether it was the alimony or the parenting agreement or something. Can you speak with people about how that works then when you come a long way?
Right.
And then,
well, I mean, the premise of the collaborative process is that everybody's coming to the table and there's going to be compromise. There's going to be compromise on both sides. And so when people do get stuck, as they often do, I mean, we try to come up with a lot of different options depending on what the parties' goals are. But what's interesting is that, one of the first things that we do in a first team meeting is we write down the goals of each of the parties. So we've got, the husband's column, the wife's column, and we start going through what are your goals for this process? What are your goals for today? What are your goals for tomorrow? And by tomorrow, it's not just the next day. It's much more forward thinking. And what we end up finding is that there are the same goals on both sides. So what we often do when they get stuck is we take out those goals. And because we have them written down or we have them on a whiteboard, and we take out those goals and we circle them back. Remember that you both said that this was important for you. Let's talk about some options. Let's try to develop some options that will help us get back to this mutual goal. And doing that, it kind of helps them come a little bit closer and sometimes bridge the gap. And that's a really powerful thing, is when we remind them of the shared goals that they have. Because listen, these people were married at one point, so they did something with their shared goals then. And we're now just transforming it or transferring it to how are we going to convert those goals for an intact marriage to new goals in this new family structure that's going to exist after the divorce is done. So when we do get those stuck positions, we try to circle back to those mutual goals and those shared goals, and that oftentimes will get them unstuck or will help them see something from the other side's perspective in an effort to help them make that compromise.
Almost like a reset and taking a breath and remembering and being able to come forward from that place.
Yes, and it's pretty powerful. I mean, there's some days and some issues where you think that there's not going to be an agreement on anything, and we circle back to those things, and we work really hard. It's the team works very hard to help the parties do option building and come up with different options. I mean, you have a marital home, for example, so these are the options. I mean, most of them are pretty standard. Somebody keeps the house, one person keeps the house, the other person keeps the house. You sell the house. Somebody stays in the house for a period of time and then they sell the house. And then there's some other things that people have done that get more creative. But when you start talking about these things, they're ideas that either the professionals have maybe come up with or the participants have come up with themselves. And we use that as a guidepost to come up with, option building. And then we kind of do elimination of the ones that don't seem to be a good fit. And then we focus on the ones that we need to explore a little bit further and how can we make it work. It's kind of like putting a puzzle together for them, and we're taking all the different pieces and what fits that's going to be best suited for them in their unique circumstances. And that's the other advantage of the collaborative process. It's a custom tailored settlement for the participants. People don't know that judges, as much as you go to court and the judge does the order and the judge says what's going to happen, the judge is also restricted to certain things by law, what he or she can do. The judge can't do a lot of things that participants can do on their own. They can negotiate certain settlements. They can negotiate certain terms that a judge would never be able to impose or award. So when people are doing that, they're customizing their resolution and their settlement. A lot of those things sometimes cannot ever be done in court, and so that's the beauty of the collaborative process. It allows people to really have an arrangement that is unique to them and unique to their family. And the other benefit of doing that themselves and coming up with that process and coming up with that settlement is the enforceability. People are much more likely to follow the terms of their own settlement as opposed
that they've created.
That they've created. Absolutely. What they've created, they're more likely to follow. And so again, that's keeping people out of the courtroom.
Right. So. And I liked how you were describing that as you say, okay, I want this to happen, and then to tailor it. So at the outset, you might not have agreement in the two parties, but as you keep working it and figure out what puzzle pieces you can add to that and how you want to arrange them, it probably is the reason why then you can come to an agreement as you're adding those pieces and shifting it to accommodate what's most important.
Right, and you will be surprised too through this process. I can't help but compare to litigated cases that I've had over the years where people get very fixated on, what they're entitled to, for example,
Mm-hmm.
either by law or what their lawyer has told them.
Mm-hmm.
And when I have seen those same issues or similar issues in the collaborative cases, all of a sudden you see people agreeing to do more than what they might be required to do by law. And that's really refreshing, because it's taking them out of the stress of litigation. And now that they're in this process, you're kind of reminding them and bringing them back to the fact that this is the person that you have been with for however many years.
Mm-hmm.
This is the person that you've created a family with. And I think that when you focus on that part of it, it then opens up the space for people to say, okay, well, how can we just make some shifts here and there, but still support one another, even though we're not going to be married to one another.
Wow.
So that's really powerful there as well. So, it's very surprising to see how much more people are willing to do in the collaborative process than they would ever in a court of law.
And that's not because they're losing or giving in, or in that
It's not that dynamic.
Right.
It's not that dynamic. It's not a win-lose dynamic.
Right.
The collaborative process really fosters a win-win dynamic. Not that anyone's getting 100% of whatever they want, but it's a win-win in the sense of the family, the assets of the family, the confidentiality of the family, and the family relationships as a priority of that and going forward. So it really goes from the win-lose dynamic to a win-win dynamic, which I find is critical for people that are going to now live in a new family system after their divorce.
Right. And probably part of that, being able to take it out of that win-win, is you're not seeing, like you're saying, that person as your enemy to fight. It is a person, right? They're remaining a person to you.
The collaborative process allows the participants to recreate a new partnership.
Mm-hmm. Right.
So again, and when you have children, I think it's critical. It's critical that you reestablish new boundaries, you reestablish a new way to communicate, and again, we want to shift them from looking at the mistakes of the past, the reason why they are where they are, because we all know everybody gets to the place where they say, okay, that's it, we have to call it quits, we're getting divorced. We all know that there's many reasons why people end up there, but the idea is to not focus on those reasons. It's to focus on the new things that are going to happen in the future. How are we going to co-parent? How are we going to keep the things, the marital estate that we've grown together? How are we going to keep that in our hands and our family's hands, as opposed to handing it out to all these other people?
Right.
Okay. So that's an important concept that collaborative participants, I think, are really have a great advantage if they can embrace the process. Because it is really the time that it takes to get from start to finish is immensely shorter, and therefore the cost is immensely shorter. Typically.
Right. Right. There's a range.
There's no guarantee of any fees in any divorce case, but I think that when it's going to take less time, and you can be done in 6, 7, 8 months versus 1 or 2 years. Time equals money, and it's everybody's time. It's the participant's time. Who wants to be stuck and embroiled in litigation for years? Not many people.
Right.
Not many people. They want to get it done. They want to, and it's not getting it done quickly, but it's getting it done efficiently, I think, is the more relevant term for people. It's getting it done efficiently and getting it done in a process and a pace that makes sense for the family.
Awesome. Well, thank you so much for being here, Carina, and sharing what is most meaningful to you about all of the options and letting people know about them. And if people want to know about you, and there will be some information in the podcast, but if you could share with them how they would be able to get a hold of you.
I'm an attorney with the O'Mara Law Group. We're located at 221 Northeast Ivanhoe Boulevard. Here in Orlando, and my email address is carina@omaralawgroup.com. I'd be happy to talk to anybody about the collaborative process or their family law issues.
Awesome. Thank you very much.
Thank you.